ignore that. Okay, for conflicts of interest, for local government officials, we need to think about certain defined terms that will appear throughout the statute. First of them is public servant. This is an individual, so not a corporation, not a business entity, not an association, an individual who is either elected or appointed to office to discharge a public duty for a governmental entity. It's also a person who's authorized to perform an official function on behalf of and is paid by a governmental entity. So that could be, for the county, might be if you've appointed someone to serve as a collective bargaining representative or to be your insurance broker or something like that. A vendor who's in charge of your entire data system could be a public servant under certain circumstances. An individual who is appointed in writing by a public official to act in an advisory capacity to a governmental entity on a contract or purchase. And this might involve, think of something really, like designing let's think about this, data processing, something that there's no one on staff who has the knowledge or the expertise to be able to, say, design a new data processing system or to design a multi-level office complex. And you may want to give them some sort of official capacity to operate for you. So you may appoint them in writing to do this for you. And again, this probably happens more typically, again, in the collective bargaining area. Those people are also public servants. They may not be aware that they're a public servant, but they are. And they don't even have to be paid to be a public servant. So, obviously, an elected official is a public servant. An appointed official, like a member of the park board or a member of the BZA or a member of the plan commission, is a public servant. Employees of an elected or appointed official are public servants. An individual, and in this case, the word that's used is person generally, an individual or a firm that is appointed in writing to assist the elected official with a purchase or a contract can be a public servant. Pecuniary interest is the next defined term that will appear not only in the criminal conflict of interest statute, but in other conflict of interest statutes. A public servant has a pecuniary interest in a contract or a purchase if that contract or purchase will result or is intended to result in an ascertainable increase in the net worth or income of the public servant or certain dependents. There is no case law on what is meant by ascertainable increase, but the term ascertainable usually means to make certain or clear or to be definitely known. So if a contract or purchase is not likely to, all of a sudden make you a millionaire, that would probably be ascertainable if you became a millionaire on the basis of a contract with county. I'd like that contract, but not going to happen. Generally speaking, pecuniary interest is limited to a direct interest related to money, but there could be situations when, say, interest in a piece of property might be a pecuniary interest if that all of a sudden that property increases in value greatly. Okay, governmental entity. There's a long list in the statute. For our purposes, the county is a governmental entity. The boards and commissions of the county are governmental entities. County office holder, that office may in and of itself be a governmental entity. Then the next defined term we have is governmental entity served by the public servant. And this generally, if you think about a county office, you'll have the elected official, and then you might have an appointed deputy, you might have employees. Those employees and perhaps appointed persons, perhaps even the deputy, the government entity they serve may be that office. But maybe the government entity they serve is not necessarily the county. On the other hand, the clerk or the auditor or the assessor, the governmental entity they serve, in most cases, is going to be that county. Now, for clerks, there may be some situations in which it's the state that they serve because they have certain judicial responsibilities. But generally speaking, the governmental entity they serve is going to be the county. And the next defined term is dependent. The public servant's spouse is deemed to be a dependent. Your minor child, stepchild, or adoptee. An individual for whom you provide more than half of the support in a year. Question was raised yesterday in another conference that I was at. What about domestic partners? Well, the statute doesn't say that a domestic partner is a dependent, at least for purposes of the conflict of interest statute. I understand that state personnel guidelines, however, provide that a domestic partner is a dependent for certain purposes of state employment. So here's the big statute. This is the criminal conflict of interest statute. A public servant, we know who that is, who knowingly or intentionally, that doesn't mean you kind of accidentally fall into it. You know what you're doing and you have the intent to do it, has a pecuniary interest in, or derives a profit from a contract or a purchase connected with an action by the governmental entity served by the public servant commits conflict of interest. And so let's go back and think about the definitions a little bit. This is going to be limited to a contract or a purchase, and we kind of all have an idea of pretty much what that means. It doesn't include things like my neighbor is going to have the property rezoned. This is a contract or a purchase, and it's that's being awarded or by the governmental entity served by the public servant. Now, it used to just say by the governmental entity, and there were a lot of folks who said, "Well, okay, but I work for the assessor, so what's my governmental entity? Is it the county or is it the assessor's office?" And so, I don't know, almost 10 years ago now, the General Assembly decided to sort of narrow that focus so that at least with regard to conflict of interest, the fact that you work for the assessor's office and your spouse happens to work for a contractor who does work for the highway department didn't mean that you had a conflict of interest because your spouse had a contract with the highway department. There are exceptions to what constitutes a conflict of interest. It's not an offense, or it's not conflict of interest if the public servant or your dependent receives salary, either through an employment situation or through an employment contract, for services they provide as a public servant, or for expenses incurred by the public and servant that are appropriate under law. It's not conflict of interest if the interest in the contract or purchase and all other contracts or purchases made by the governmental entity during the 12-month period before this last contract was $250 or less. So let's say your wife owns a small printing company that does a lot of business with the county doing printing, but and you are, let's say, you work in the highway department. You might have a conflict of interest if somehow or another you're going to earn more than $250 spread out over the year on these contracts. If you're not, then there's not a pecuniary interest. That's sort of the safe harbor. So for most small contracts, maybe you don't get to $250 in terms of a increase in your ascertainable net worth or your income over a year. but $250 may seem kind of small to be a safe harbor these days. It's not conflict of interest if you are not on or the staff of or a member of the governing body that actually makes the contract or purchase. And your responsibilities as a member of the governing body, or more likely as a member of the staff, are not related to that contract or purchase. So think about county park department. A member of the park board may have a conflict of interest if their primary function is to award contracts. If it's not, then not. Then let's take the golf pro. The golf pro who takes care of the county's public golf course is not the person who actually does the contracts for maintenance and lawn care and for concession services, then it's not a conflict of interest. If, however, that golf pro is a member of the staff of the park department and is the person responsible for awarding those contracts, then they've probably got a conflict of interest. But there's a big loophole. When that happens, you just make a disclosure under the statute. And any of you who've been around a while have probably seen the form, may even have had to fill out the form, maybe have advised someone in trying to be cautious and foresighted to go ahead and fill out the form in the event you might have a conflict. Okay, it's not an offense, not conflict of interest. Again, if you're an elected official or an appointed official who's appointed by an elected public servant, and you make the disclosure. So things that look like they're conflicts, excuse me, are not conflicts so long as you disclose them. It's not an offense. We've already done that one. That shows up again. Okay. The disclosure that you must make has to be in writing, has to describe the contract or the purchase to be made by the governmental entity, describe the pecuniary interest that the public servant has in the contract or purchase. Let's say you have a silent partnership interest in the engineering firm that's going to design the new county bridge. You need to disclose that. And disclose, is it going to increase your net worth? If it's not, you need to demonstrate why you don't think it's going to. You have to, it has to be affirmed under penalties of perjury, which means you have to say, I'm not lying. And has to be submitted to the governmental entity before the contract is awarded. It has to be approved by the governmental entity, too. If you are an appointed official, your elected official also has to sign off on it before. Now, the State Board of Accounts has a form. This is an easily available form. I even have it copied and PDF'd on my desktop so that I can have it. And this is the basic criminal conflict of interest statute that applies to everybody. But it's not the only conflict of interest statute. Redevelopment commissions have their own conflict of interest statute. That doesn't mean that the criminal one doesn't also apply, but they have one that specifically applies to redevelopment commission members. Neither a redevelopment commission member or the non-voting school advisor may have a pecuniary interest, again, whatever pecuniary interest means, in any contract, employment, purchase, or sale made by the redevelopment commission. Any property required for the redevelopment purposes in which a member or the non-voting advisor has a pecuniary interest may be acquired, but only if it's given to the redevelopment commission or it's condemned. And since redevelopment commissions no longer have the power to condemn property except through their legislative bodies, you're almost never going to see a redevelopment commission get property through condemnation. And a transaction that does not comply with all these requirements is void. So let's think about it. You've got a local banker on the redevelopment commission who just coincidentally happens to have an option to purchase this really, really valuable piece of property. In fact, that the redevelopment commission wants to offer to a new economic development prospect. And knowing that, the redevelopment commission member says, the banker says, I'm going to go ahead and buy that piece of property. That's fine. But then he can't sell it to the redevelopment commission. He can give it to the redevelopment commission, but he can't sell it. And so that's why a lot of times people who work with local redevelopment commissions will confirm with the folks that they want to appoint to a redevelopment commission that you're not going to all of a sudden have a real estate interest here or become the only place where I'm going to be able to sell the county's bonds, the redevelopment commission's bonds. Because if so, I really don't need you on the commission. Economic development commissions also have a conflict of interest prohibition. If any property that an economic development commission member or a county council member has a pecuniary interest in is required for an economic development project under the economic development statute, it's kind of like the redevelopment commission. The economic development commission can acquire the property, but only by gift or condemnation. So again, an economic development commissioner can't simply sell the property or purchase the bonds of the EDC. That voids the transaction. In addition, if an attorney who represents the Economic Development Commission, that attorney, nor anybody in that attorney's firm, so think about some of the really large law firms you know, can represent an applicant for a financing before the commission. So let's just say, one of the partners and they don't have to be a big firm, let's say in the biggest law firm in the county always does the Economic Development Commission's work. Well, that's fine. But no other member of the firm may now represent somebody who wants to seek an incentive or financing before the Economic Development Commission. Now, this statute doesn't have the same language that the Redevelopment Commission statute has, which says whatever you do is void, but it's not supposed to happen. So, plan commissions. There's a conflict of interest provision that applies to members of plan commissions. A member of either the plan commission or the legislative body is disqualified and may not participate as a member of the plan commission or the legislative body in a hearing or recommendation of the commission or legislative body concerning a zoning change in which the member has a direct or indirect financial interest. And the facts about that disqualification must be entered in the records of the Plan Commission. BZAs have a similar requirement. A member of a Board of Zoning Appeals is disqualified and may not participate in a hearing or decision of the BZA concerning a zoning matter if the member is biased or prejudiced or is otherwise unable to be impartial or has a direct or indirect financial interest in the outcome of the hearing or the decision. And just as with the Plan Commission, those facts must be entered into the record of the BZA. So we have, and I wanted to point out that in the BZA statute and the Plan Commission statute, not only are you disqualified, you may not participate. There's no such provision in the criminal conflict of interest statute. A lot of times people just assume that if they don't vote on the matter in which they have a financial interest, then there's no conflict under the criminal statute. That is not true. The criminal statute does not provide that abstaining cures the conflict. Now, that is different than the statute that applies to state employees who are if they have a perceived financial interest in a contract or purchase, must disqualify themselves and must disclose it and are required to abstain from any further consideration of the matter. So let's look at 3K, because I was told that conflict of interest in the land use area was something that folks were particularly interested in. So the most recent case is Perry Worth Concerned Citizens versus the Board of Commissioners of Boone County. And in this case, and it's now 18 years old, so I'm not sure that it really is the most recent case, but it's certainly the most definitive case on this issue. Property owners challenged an ordinance, so that would be an ordinance of the commissioners usually, except in Lake County and St. Joe County, in which it would be the county council, but they challenged the rezoning ordinance, alleging that the county commissioner one of the county commissioners who voted on the ordinance was disqualified because his wife had an interest in property adjacent to the property for which the rezoning was sought. The court said that the focus should be on whether the direct or indirect interest, which is the zoning matter, and not whether it was the property in which there was an indirect or direct interest. The commissioner was not disqualified because he had no interest, either direct or indirect, in the zoning of that particular piece of property. The court also said there's no conflict of interest because the case involved a legislative determination, and that the appearance of impropriety doesn't apply to legislative bodies, unlike administrative bodies, which is going to be the next entity we're going to look at. Fale versus LaPorte County Board of Zoning Appeals. In this case, neighboring property owners sought review of the BZA's grant of a variance and special exception that complied with the zoning ordinance on the grounds that one of the BZA members had a conflict of interest. The Court of Appeals noted that the determination as to the existence of a conflict of interest is, generally speaking, an issue of fact. And it's not limited to determining whether a party actually exercised improper influence. A conflict of interest can be found when the situation could be reasonably calculated to weaken public confidence in and undermine the public's sense of security for the protection of individual rights in the exercise of the zoning authority. So in this case, because it's the BZA, it was important that everything look proper and above board. But apparently it doesn't matter if it's the legislative body, because legislators are allowed to be different than appointed officials. I have to be careful here. Stokes versus the city of Mishawaka. And I realize it's a city case, but it also involved county landowners. The homeowners challenged the zoning ordinance on a lot of reasons. One of them was conflict of interest, because the petitioner for the zoning ordinance change was represented by a council member's son. They said the council member's participation and his vote violated the appearance of fairness, the appearance that it appeared to be improper. And the court said, doesn't apply here. It is well settled that courts cannot inquire into the motives of a local legislative body when acting in a legislative capacity. And when a governing body acts on rezoning applications, it exercises a legislative power. So not a fact-finding power, not an administrative power, a legislative power. I think that's it. Any questions? In the back, Luke. Typically, I'd like to solve as many places as possible with them, but I'm sorry. I need the microphone. The question from Luke Britt, who's the public access counselor, was who or what entity is the proper custodian for these filed conflict of interest disclosure statements. For local government, the State Board of Accounts gets a copy, always. And then the clerk of the circuit court, aren't you lucky, are supposed to get a copy for all local officials. Now, I'm going to guess that some municipal entities see the word clerk and assume that just means the municipal clerk. So I always suggest to my municipal clients that you're supposed to file it with the Board of Accounts. You're supposed to make sure the circuit court clerk has it. But in an overabundance of caution, just go ahead and have a copy on file in the municipal office. And one of the reasons is that frequently the public can be funny. And they may think there's a conflict, or they may think that someone should have filed a conflict, and the public isn't going to necessarily know, let's say if it involves the town of Paoli, that they need to be checking with, they might know to check with the Board of Accounts, maybe, but they're probably not going to think town of Paoli circuit court clerk. So they're probably going to go to the clerk treasurer's office and say, could I see the conflict of interest form for council member XYZ? Well, at least it's there, and maybe you've, provided them the information they need, and most wise officials will say, oh, there's also a copy on file in this place or in this place. But generally speaking, local documents always get filed with the Board of Accounts and with the circuit court clerk. Any other questions? What about you? Okay.
Do elected officials need to file those every year, or just when they get elected?
Okay. The question is, do elected officials need to file a conflict of interest statement every year, or just when they're elected? Technically, they need to file it, and it's not just elected officials, but elected officials, every time they might potentially have an interest, a pecuniary interest in a contract or a purchase. For people who, let's say, have a spouse who is engaged in a profession that routinely does a lot of business with the city or the county or the town or the township, the statute doesn't require it, doesn't even speak to it. But again, in the interest of transparency and letting the public know what's going on, we frequently suggest to folks who have that kind of situation, file an annual disclosure that says, my spouse works for XYZ engineering firm through the course of the year. We may, I may receive a pecuniary interest in a contract or purchase. And then if it actually arises, then of course you would file another conflict of interest statement. So to demonstrate it. Now the first one is just an overabundance of caution, because sometimes people assume that just because this council member or this clerk is married to this person in this engineering firm that they have to have a conflict of interest. Of course they do, because everybody knows that he does work for the county or he does work for the city. So sometimes it's just easier to err on the side of caution and to provide more information than is maybe technically necessary.
But wouldn't the full disclosure when you become a board member be adequate to explain what businesses you may have?
Well,
What kind of information?
that's a different kind of disclosure than the conflict of interest, because the only time you have to file the criminal statutes form is when the conflict of when an interest in a contract purchase arises. But let's say there are other situations, and the state has this form that requires the disclosure of financial interests, regardless of whether or not you do business with, if you're on a board of this committee, if you have more than a certain percentage ownership in a business, regardless. That's a different disclosure form than the criminal conflict of interest form. And I used to work a long time ago for Indianapolis and Marion County, and we had a form similar to the state form, which requires disclosure of interest in businesses if you have more than a 5% interest, if you receive gifts, that sort of thing. So it's a little different, a little broader than the criminal statute. Anything else? I think I'm done, Christine.